16. Law of Trademarks. Chapter 2, Section 20. Right to protection. The United States statutes promise protection to lawful trademarks, upon certain conditions. In its ordinary acceptation, this word protection is sufficiently well understood. Its legal sense is not always so clear to the novice. Applicants for registration sometimes seem to think that a bit of ribbon and the official seal of the Patent Office possess a magical potency to ward off piracy, without requiring on their parts the slightest care or concern. In a recent case in the Patent Office, the proprietor of a registered trademark indignantly called attention to the fact that other persons were importing his class of goods, Havana cigars, and demanded the instant interposition of the government on his behalf. It was evident from his communications that he expected the Queen of the Antilles to be blockaded, and that an armed force should be maintained, on land and sea, to prevent anyone from bringing in cigars like those to which he had affixed his mark. He said that he had paid his money for his certificate, and now he must be protected. He was informed that the protection was not promised to be given in that way. Physical force was out of the question. He must look to the judicial branch of the government. Section 21. Alien friends. In the courts of the United States, under the Constitution and laws, foreigners are entitled, being alien friends, to the same protection of their rights as citizens. And this does not depend upon reciprocity. The cannibal of the Fedjis may sue here in a penal action though having no courts at home for us to resort to. But an alien is not now regarded the outside barbarian he is considered in China, and the struggle in all commercial countries for some centuries has been to enlarge his privileges and powers as to all matters of property and trade. Says Woodbury, J. Comity and courtesy are due to all friendly strangers, rather than imposition and pillage. Taking their marks and using them, as, and for theirs, to their damage, is like preying on a visitor, or inhospitably plundering a rencontre. It is a pity that the spirit of enlightened liberality does not exist in all civilized nations. In Luxembourg, foreigners not domiciliated have no action to recover damages for usurpation of marks and names. So in some other countries. Section 22. The Committee of Nations demands that all kinds of commercial property be protected, no matter what may be the nationality of the suppliant for justice. The case of Christoffel and Company v. Deliideria, in the Tribunal of Commerce of Geneva, in 1859, shows that another nation may lay claim to enlightened liberality in this respect. It was substantially held that the name of a manufacturer, and his mark, are his property under the laws of nations. This doctrine has long been maintained by eminent jurists of France and Germany, and as the nations find it to be their best interests to throw down the barriers, it is fast approaching universal acknowledgement. It is not governed by the same rules as analogous rights, like a copyright or a patent for an invention or discovery, for such property is held to be local in its character, as well as artificial, while a right to a distinctive emblem of one's individuality, as his signature or his mark, does not depend upon anything beyond one's own will. He made it, it is his. So, it may be said, is a man's right to the children of his brain. True. But to them has never been applied the maxim, debitum et contractus sunt nullius loci. They have not yet been brought into the domain of commerce. It is not regarded as piracy to steal such things from people of other nations, who are not protected by treaty. But whoever infringes a trademark in any part of the commercial world commits a tort, and the law should give redress. Section 23. Although emphatically or tacitly admitting the justice of claimant's title as resting upon the law of nature, the legislatures and tribunals of some European states have stultified themselves by denying the right to protection. In 1841, the Tribunal of Commerce of the Seine, by 2 judgments, decided the principle that the commercial name of a merchant is a property that the laws of all countries should respect. Yet the plaintiffs, Messrs. Rowland and Son, of England, whose name as a mark for Macassar oil had been pirated, were eventually denied the aid of the court, because aliens. Section 24. Mutual confidence is the bond of union between nations. It follows, therefore, that whoever weakens it is an enemy to all mankind. He becomes a pirate, and whether preying directly upon commerce on the high seas, or by knavery and trickery upon the land, he is regarded as a common foe, to be dealt with, when coming within the iron grasp of the law, with a just rigor. Mutual reliance must be the rule. Every act of trade by which operations to an almost boundless extent are daily transacted, is essentially founded upon confidence. By the simple delivery of bits of paper bearing certain signs, millions of dollars are hourly transferred, and contracts of the greatest magnitude are made upon the description of a mark or name. Being a common enemy, the robber of his neighbor's honor or property is pursued by the accredited protectors of commerce. It has been well said that the degree of civilization to which a people has arrived follows exactly the degree of guarantee that the law of that people affords to property. The eternal principles of justice have been recognized, but an armed neutrality has been maintained, at the risk of sapping the foundations of morality and self-respect. Harmony of action may soon come. Joe Budd, in 1851, enthusiastically entered upon the contemplation of this subject, as he welcomed the humanitary palingenesis then preparing itself. Whilst deploring the state of things then existing, he indulged in a sad tone. But there is no doubt that the animadversions of such men as he greatly assisted in bringing about the desired change. Section 25. Monsieur Joe Budd said that the age of shepherds succeeded the age of hunters, the age of cultivators that of shepherds, and we have entered upon the industrial age, but we enter thereon as foragers. We have free course, because the domain is still without hedges, without ditches, without enclosures. Each encroaches on his neighbor, and hunts and kills him if he be the stronger. All means are good, trickery and theft, ambuscade and violence. It is a conquered country without laws, without rules, without magistrates, where capers the dishevelled anarchy that certain sophists decorate with the title of free competition, as certain others call robbery a just and courageous reclamation of the goods of his ancestors. After the lapse of 20 years, we see the bright dawn of a more hopeful day. Nearly all the states of Europe have combined to effectuate the desire of his heart. France itself has made more than 30 treaties and conventions on the subject of the protection of the fruits of intellectual labor, and the enterprise of the manufacturer or merchant. Philosophers, moralists, jurisconsults, statesmen, political economists, all have paid their tribute to this and kindred subjects, and now they see a clear horizon in the sphere of human activity, and behold the breaking down of the barriers of suicidal prescription. Section 26. Legislation on this subject has until of late been vague, uncertain, incomplete. Jurisprudence, however, has resolved innumerable questions by the light of natural justice, the law written in men's consciences, that immutable code inscribed by the great legislator on the soul. France by her law of June 23 d. 1857, England by the Merchandise Marks Act of 1862, and the United States by the law of July 8, 1870, in relation to trademarks, have concurred in recognizing the necessity for more adequate protection than that afforded by pre-existing statutes or the common law. The Austrian law of December 7, 1858, that of Sardinia of March 12, 1855, and the many treaties for the like purpose, all display the same spirit. Said an able writer in France, in 1855, the moment has now come for each state to prescribe in its legislation that the names and marks of manufacturers of its own nation or of foreigners shall be inviolable, and shall find equal protection before the tribunals. His dream has come true. Thanks to steam and electricity, which are annihilating distances, a noble and enlightened competition has been established. We are no longer in a time when each kind of commerce and of industry is centralized in one spot, in a city, or in a region. The new ideas of civilization now open to us the Empire of Japan, and even the flowery kingdom has begun to smile upon outside barbarians. Verily, a trademark has become a thing of moment, for it spurns the thraldom of territorial limits. Section 27. We may adopt the ideas of Professor Leon Levi, F. S. A. and C. in speaking of the lofty position gained by British manufacturers. He spoke some years before legislation had assumed definite proportions in this regard. He said substantially that the British manufacturers are well alive to the demands upon their skill and energies, and we see them everywhere striving to rival all competitors, and to maintain untarnished the reputation they have gained. Their aim is to produce articles which for their price may be unequaled and unexcelled in this or any other country. and whenever they stamp such articles with their names, ciphers, or labels, they enter into solemn guarantees that the goods so marked shall invariably be of the quality represented. Their endeavor is to establish such an intimate relationship between the manufacturer and the manufacture, that in whatever market such goods may be exposed for sale, the same may be received with the most implicit faith and reliance. A mark on a manufacture is like the impress of the sovereign's coin, a sufficient evidence, universally accredited, that the coin is of a specific rate and fineness. Why should it not be now as in former times, when the mark was not simply the signature of the merchant or manufacturer, but also a certificate of quantity, given by public authority, touching the quality of the produce, its origin, weight, and c. Section 28. Trademarks are assuming increased importance from the fact that in Europe, there is a growing tendency to abolish or greatly restrict the granting of patents for inventions and discoveries. This question of political economy has so far prevailed that in the Empire of Germany, in Belgium, and in other countries, official inquiries are being made as to the working of the patent laws and their effect upon the general welfare. Many statesmen and jurists believing that the system of monopolies, as they miscall it, has not met the expectations of the lawmakers. In Holland, we are informed, both legislative chambers have abolished the system entirely, the votes lacking but 2 voices of unanimity. Although such retrogression cannot be expected to occur in this developing country, with its myriads of ingenious artisans and earnest explorers of the inmost recesses of nature, minds intent upon releasing the human frame from the thraldom of drudgery, it is well to know what other nations think and do. It may be that in those countries labor is so cheap that human muscle and life rate with those of the beasts that perish. Be that as it may, in regard to artificial property like patents, the rights of manufacturers and merchants rest on exterior signs, which have for an object to make known their industries and the products thereof. Lawful competition is open to all. All that is demanded is that encroachments upon the business mark of another be prohibited. The Master of the Rolls, in Croft v. Day, said, "The principle in these cases is this, that no one has a right to sell his own goods as the goods of another." Section 29. The world-renowned Wedgwood produced many fine pieces of work, which only his master hand could afterwards improve. He did not patent his inventions, but with a consciousness of his own superiority, which he ever maintained, he permitted all other potters to follow as nearly as they could in his footsteps. His trademark was ample protection, and indeed was more efficacious than any patent could be, unless we consider that he did possess an unencroachable patent, that bestowed by excellence itself. By means of his symbol he secured a full reward for his industry, his toil, his genius. With the largest manufactory of China and Queen S-ware in the known world, he could safely rely on this trademark to point out to the people of all countries the goods in which he so successfully combined the useful, the ornamental, and the ingenious. Section 30. Imposition upon the public, occasioned by one man selling his goods as the goods of another, cannot be the ground of private action or suit. This is a definitively settled rule. We must not, however, dismiss this rule from further consideration until we are sure that we comprehend the scope of this brief enunciation. To speak more plainly, the mere fact of fraud upon the public will not induce a chancellor to interfere unless the plaintiff has sustained, or there is good reason to believe that he will sustain, pecuniary damages. Imposition on the public becomes the test of the property in a trademark having been invaded and injured, but it is not the ground on which the court rests its jurisdiction. Section 31. The Lord Chancellor, in Spottiswoode v. Clark, in 1846, said that these cases depend so much upon their own circumstances, that all that the court can do is to lay down principles under which such cases may fall. I have before this had occasion to express an opinion, that, unless the case be very clear, it is the duty of the court to see that the legal right is ascertained before it exercises its equitable jurisdiction. For this there are good reasons. The title to relief depends upon a legal right, and the court only exercises its jurisdiction on the ground that that legal right is established. Our objection to granting an injunction, in the first instance, is, that it promotes after litigation. The order either grants an injunction, and compels the plaintiff to bring his action, or suspends the injunction, with liberty to the plaintiff to bring his action. If you compel him to go to a court of law, you promote litigation, and this course is forced upon parties when their feelings are deeply engaged in prosecuting their imaginary rights. There is also another objection, which is, that the court expresses a strong opinion, and it ought to be a strong opinion, and then sends the right to be tried. I think it better that the court should abstain from expressing such an opinion. But, after all, the chief objection is, that the court runs the risk of doing the greatest possible injustice. Section 32. When a person has adopted and used a particular mark, to indicate to those who deal with him that an article is manufactured or sold by him, or by his authority, others have no right, without his assent, with the view of deriving advantage from the same, to use such mark without change, or even with such colorable difference as is calculated to deceive the proprietor's customers, or the patrons of his trade or business. Such mark, when it has become known, is a species of property, and its owner will be protected against the attempt of others to appropriate to themselves, by its use, the benefit which such is entitled exclusively to enjoy. But there can be no harm done to the owner of which he has the right to complain, unless his trademark be appropriated without change, or unless it is simulated in such a manner as probably to mislead his customers, or the patrons of his trade or business, inducing them to suppose that in purchasing the article marked, they are purchasing that manufactured or sold by such owner. Section 33. It is frequently a difficult matter to determine what is an infringement. The two marks, which are supposed by the plaintiff in a case to conflict, may resemble each other, and yet be different. The question then rises, is the difference only colorable? No general rule can be laid down as to what is or what is not a mere colorable variation. All that can be done is to ascertain, in every case as it occurs, whether there is such a resemblance as to deceive a purchaser, using ordinary caution. In the case of the leather companies, in the House of Lords, in which remarks as follows were made, it was further said by Lord Cranworth for the court that in that case the difference was so palpable that no one could be deceived. In the first place, the shape is different. The plaintiff's trademark, if trademark it is to be called, is contained in a circle. The design of the defendant's is a semicircle mounted on a parallelogram. It is said that the defendant's goods may be so rolled as to expose only the semicircle, and so lead to the belief that the device, in its integrity, is a circle. There might, however, be some force in the observation if the upper half were the same as, or even if it closely resembled, the upper half of the plaintiff's device. But this is not so. The name of the company is different. The word Crockett is prominently exhibited twice in the plaintiff's upper half, not once in the defendant's. No one taking the trouble to read the two can say that he would be deceived. Section 34. The ownership is allowed, that one may have the exclusive benefit of the reputation which his skill has given to articles made by him, and that no other person may be able to sell to the public, as his, that which is not his. An imitation of his mark, with part differences, such as the public would not observe, does him the same harm as an entire counterfeit. If the wholesale buyer, who is most conversant with the mark, is not misled, but the small retailer or consumer is, the injury is the same in law, and differs only in degree. The right of action must exist for the last, as well as the first. If all consumers do not discriminate in the end, it would be indifferent, even to the wholesale buyers, from which of two they bought, and thus the extent of the injury would be as great as if they also were deceived. Section 35. The question is not whether the complainant was the original inventor or proprietor of the article made by him, and upon which he now puts his trademark, or whether the article made and sold by the defendant under the complainant's trademark is an article of the same quality or value. But the court proceeds upon the ground that the complainant has a valuable interest in the goodwill of his trade or business, and that having appropriated to himself a particular sign or mark, indicating to those who wish to give him their patronage that the article is manufactured and sold by him, or by his authority, or that he carries on business at a particular place, he is entitled to protection against a defendant who attempts to pirate upon the goodwill of the complainant's friends or customers, or the patrons of his trade or business, by sailing under his flag, without his authority or consent. Section 36. The public should be protected. Mr. Justice J, in his very able opinion in the case of the Muskeg Manuf Company v. Speer, enunciated as one ground for protection the benefit to the public at large. The plaintiff's trademark is an assurance to the public of the quality of the goods, and the pledge of his own integrity in their manufacture and sale. To protect him, therefore, in the exclusive use of the mark that he appropriates, is not only the evident duty of a court, as an act of justice, but the interests of the public, as well as of individuals, require that the necessary protection should be given. Brady, J., in Matsell v. Flanagan, said that the enforcement of the doctrine that trademarks shall not be simulated, does not depend entirely upon the alleged invasion of individual rights, but as well upon the broad principle that the public are entitled to protection from the use of previously appropriated names or symbols, in such manner as may deceive them, by inducing to the purchase of one thing for another. He took the extreme ground that it is not necessary to the exercise of judicial powers that the plaintiff should have any other property in the name used than that possessed by other persons. He said that there is neither honesty nor honorable competition in adopting, for a similar purpose, a name used by another, if it be employed in such a manner that the public may be imposed upon, and such a result must follow if the simulation be so successful that one article or creation is purchased or accepted for another. He regarded those principles as established by the adjudged cases of both England and this country. Robertson, C.J., in Swift v. Day, which was a controversy in regard to a trademark on matchboxes, said that is eminently a question of fact, to be submitted to the practical experience of a jury, whether in a particular case a resemblance was likely to deceive the community. There is no article of more general consumption, less value, or more frequently bought by ignorant or careless purchasers, than friction matches, none, perhaps, when their degrees of excellence are more widely apart. In such a case, the general appearance of whatever is adopted as a trademark must control, because it is the unwary, and not the wary, who are to be protected, as most likely to be taken in by its counterfeits. Bosworth, J., in Gillett v. Kettle, said that the fraud complained of consists in selling an inferior article of the plaintiff's manufacture as being one of a superior quality. The fraud, to the extent that it may be successful, is twofold. The public is defrauded by being induced to buy the inferior for the superior article. The plaintiff is defrauded by an unjust destruction of confidence that his pens are put up for sale, and assorted, with reference to the quality, indicated to dealers by the labels on the boxes which contain them. By such a practice the defendant endeavors by a false representation to effect a dishonest purpose. He commits a fraud upon the public and upon the manufacturer. The purchaser has imposed upon him an article that he never meant to buy, and the manufacturer is robbed of the fruits of the reputation that he had successfully labored to earn. In such a case, there is a fraud coupled with damage, and a court of equity, in refusing to restrain the wrongdoer by injunction, would violate the principles upon which a large portion of its jurisdiction is founded, and abjure the exercise of its most important functions, the suppression of fraud and the prevention of a mischief that otherwise may prove to be irreparable. This language, which has the ring of the true metal, is substantially that of J., of the same court, in the Muskeg case. Fraud and damage resulting therefrom always entitle the injured party to relief, provided, of course, that he come into court with clean hands. The public, as an innocent party, for a party it must be considered, although not directly on the record, should be sedulously guarded by the action of the tribunal which holds the culprit within its grasp. J., in the Muskeg case, said, that it is the evident duty of a court as an act of justice, and the interests of the public as well as of the individual purchasers require, that the trademark be protected. This does not operate as an injurious restraint upon the freedom of trade. Its direct tendency is to produce and encourage a competition, by which the interests of the public are sure to be promoted, a competition that stimulates effort, and leads to excellence, from the certainty of an adequate reward. Vice-Chancellor Sandford, in Coates v. Holbrook, laid considerable stress upon the duty of protecting the public as well as the complainant from the consequence of barefaced roguery, and Story, J., in Taylor v. Carpenter, was no less emphatic, and Sandford, C.H., in Snowden v. Noah, said that the injury for which redress is given in such cases results from the imposture practiced upon the customers of an existing establishment, or upon the public. But we need not multiply instances to prove that courts will habitually regard the interests of the public at large, in acting upon particular cases, or applying the rules of justice to an individual wrongdoer. Section 37. In the Dixon Crucible Company v. Guggenheim 5 case, Paxson, J., remarked that the jurisdiction of Chancery in trademark cases attaches because of the injury to the one whose goods are simulated, by interference with his profits, not because of the deception upon the public. The fraud upon the public will not induce a chancellor to interfere, unless the plaintiff has sustained, or there is good reason to believe we will sustain, pecuniary damages. Section 38. In Comstock v. White, Sutherland, J., said, on the other hand, on a motion to dissolve an injunction, as to the public, if these pills are an innocent humbug, by which both parties are trying to make money, I doubt whether it is my duty, on those questions of property, of right and wrong between the parties, to step outside of the case, and abridge the innocent individual liberty which all persons must be presumed to have in common, of suffering themselves to be humbugged. It did not appear that the pills were positively injurious. Hoffman, J., in Fettridge v. Merchant, said the question of fraud by means of a false mark should be judged of solely as between the immediate parties, and that the public should be left to its own guardianship. Section 39. James, J., in the case of the Congress and Empire Spring Company v. High Rock Congress Spring Co., said that the doctrine of protection to trademarks is now well established. The principle which underlies the doctrine is, that he who by his skill, industry, or enterprise has produced or brought into market or service some commodity or article of use, convenience, utility, or accommodation, and affixed to it a name, mark, device, or symbol, which serves to designate it as his, is entitled to be protected in that designation from encroachment, so that he may have the benefit of his skill, industry, or enterprise, and the public be protected from the fraud of imitators. Section 40. An able French writer remarks that it is clear that the fabricant who by the superiority of his products, or by the cleverness of his manufactures, has acquired a merited renown, has a great object in investing with his mark articles of his make, to the end that such mark, which certifies them to the preference of the public, may thus secure an assurance and facility of sale. It is clear that he who sees his mark sought for by the public, finds, in his own interest, strong reasons to make incessant efforts of intelligence, and of obedience to law, to conserve to himself the preference accorded to him. It is manifest, also, that the example of marks honored, eagerly looked for in commerce, and becoming for their possessors a source of fortune, is for others a powerful incitement to walk in the same path. But on what condition shall industry really find such signal advantages? On the condition that such marks shall be truly and efficaciously protected by the law, that the manufacturer shall find entire security in the use which he shall make of his mark, and finally, that he shall receive from the law sufficient guarantees for reclamation against the counterfeiter. Section 41. In the House of Lords, in 1865, Lord Kingsdown said, the fundamental rule is, that one man has no right to put off his goods for sale as the goods of a rival trader, and he cannot, therefore, in the language of Lord Langdale in the case of Perry v. Truefitt, be allowed to use names, marks, letters, or other indicia, by which he may induce purchasers to believe that the goods which he is selling are the manufacture of another person. A man may mark his own manufacture, either by his name, or by using for the purpose any symbol or emblem, however unmeaning in itself, and if such symbol or emblem comes by use to be recognized in trade as the mark of the goods of a particular person, no other trader has a right to stamp it upon his goods of a similar description. That is what I apprehend is usually meant by a trademark, just as the broad arrow has been adopted to mark government stores, a mark having no meaning in itself, but adopted by and appropriated to the government. Section 42. Wherein consists the wrong in using the trademark of another? It is not in imitating a symbol, device, or fancy name, for in such act may not be involved the slightest turpitude. The wrong consists in unfair means to obtain from a person the fruits of his own ingenuity or industry, and injustice that is in direct transgression of that command of the Decalogue, thou shalt not covet. Anything that is thy neighbor's. The most detestable kind of fraud underlies the filching of another's good name in connection with trafficking. Section 43. A perfect system of trademarks is ascribed by Jobard to the Chinese. They excel in this institution of commercial guarantee, for nearly all the goods exported from China are enclosed in boxes hermetically fastened by paper bands, and have upon them the mark of the makers. Everything is stamped and endorsed with the firm and title of the furnisher, who is responsible for the quality of the contents of the packages bearing his name. A cargo of tea arrived one day from Canton and London, when it was found that the boxes were filled with nothing but rice straw. The vessel and cargo were immediately sent back to China. The hongs were speedily assembled, and recognized each their own marks. It was ascertained on examination that the adroit thieves, who had been employed to convey the tea from the warehouses to the ship, had slipped off with the chests to an island, and had there opened them, and for their precious contents had substituted packages of rice straw. To preserve their commercial reputation, the Chinese merchants gladly made good the loss. Section 44. In connection with patents and some other kinds of property, resemblance may be the result of accident, or of an honest difference of opinion, but in conflicts arising out of the invasion of proprietary marks, resemblance may generally be traced to meanness and cupidity. Truly did Senator Lott say in one case, a disguise is not generally assumed for an honest object. It is a mark more characteristic of deception and fraud. It defeats the very end and object contemplated by legitimate competitors, the choice to the public to select between the articles for sale, and operates as a deception and imposition on the dealer. He might have further said that nearly always it is a witness against him who uses it. Section 45. Foundation of title. Having satisfied our mind that the conventional sign of trade has a history, and an acknowledged right to protection, we next inquire upon what laws does the claim to property in it rest. How does the owner of a trademark obtain his exclusive right to its use in a particular manner, i.e., in connection with certain articles of merchandise? Is it by act of law, vesting in him the sole right of user, or is it by mere volition? Let us attempt to answer. Section 46. The right to a trademark is neither tangible nor visible, though the thing produced from the right is perfectly so. The subject matter is not the symbol, but the exclusive privilege of continually using the same to impress or otherwise mark articles of merchandise, so that purchasers may instantly know the origin of such articles. Just as a person may by his autograph indicate his workmanship, or his ownership, so may he by any other sign as a substitute therefore do the same. The right to write one's name on a piece of personal property is a natural right, so, therefore, must be the right to use its substitute, any other emblem. This right is founded upon possession, and his possession rests upon the mere act of adoption and use, for, in contemplation of law, without use there is no adoption. That this is the true doctrine we may easily convince ourselves by reference to judicial decisions. Section 47. Rhodes, J., in delivering the opinion of the Supreme Court of California in Deringer v. Plate, in 1865, said, "The right of property does not in any manner depend for its inceptive existence or support upon statutory law, although its enjoyment may be no better secured and guarded, and infringements upon the rights of the proprietor may be more effectually prevented or redressed by the aid of the statute than at common law. Its exercise may be limited or controlled by statute, as in case of other property, but, like the title to the goodwill of a trade, which it in some respects resembles, the right of property in a trademark accrues without the aid of the statute." The learned judge was discussing a local statute of his state, but the principle is quite as broad as he stated it. He further said that the proprietor may assert and maintain his property right wherever the common law affords remedies for wrongs. He might have put it more strongly, and have said that the right to the exclusive use of a man's commercial signature, or its analogue, the trademark, exists throughout the world. It is true that a remedy is not always promptly accorded, owing to the narrow jealousies of various nations in affording undue protection to their own manufactures and commerce, but the right as recognized. A foreigner's property in a promissory note, or any other kind of personal property, may be admitted, but the courts are shut to him as an alien, non-domiciliated. In this illiberal spirit some European nations have striven to extort reciprocity and privileges for their own citizens or subjects. Nevertheless, their conduct cannot affect the natural right. Section 48. In the Court of Paris, in 1863, Orbitin v. Vix et al., the court held the same doctrine, and said, the deposit of a mark of commerce is not necessary to acquire, and even conserve, the property of the mark, although the deposit is indispensable to enable one under the law of the 27th of June, 1857, to obtain the special guarantees which it institutes, and of the actions which it organizes. The same court, the next year, recognized the same doctrine, in Stubbs v. Astier et al., and the Court of Cassation, by its final judgment on appeal, effectually shut the door in the face of confessedly just claims, for the reason of alienage alone. Section 49. The Court of Cassation, in 1864, Leroy v. Carmels, held that the deposit does not constitute the exclusive right to the property of the mark, that deposit is necessary only for the purpose of enabling the proprietor to sue for damages for infringement, and that it was necessary to search whether the mark in controversy did not exist at a period anterior to that of deposit. Nothing can be plainer than this enunciation of the Supreme Court of France. The right to a thing may be perfect, but the right to claim reparation for an encroachment upon that right may not have any foundation. Section 50. The Court of Paris, in 1867, in Sargent v. Rome, said that in ancient legislation as well as in the new, the legal deposit of marks was simply declarative, and not attributive. Consequently, a deposit merely creates a presumption of proprietorship. In the same court, in 1868, Holzer F. Company v. Lendenberg & Co., it appeared that the plaintiffs, proprietors of certain steel works in France, had ever since the year 1834 been using as a trademark the figure of a bell, and their products became known under the name Écailles et la Cloche, Bell Steel, and acquired a reputation for superiority. After the Treaty of 1862, between France and the Zollverein, the Prussian manufacturers, Lendenberg & Co., established a warehouse in Paris, near that of Holzer & Co., and their wares were also marked with a bell. Holzer & Company sued them for infringement of their trademark. The Prussian house thereupon established the fact that ever since 1817 they had marked their products with the same device, and invoked on their behalf the benefit of the treaty aforementioned. They did not rest their claim to the exclusive right of user upon aught but possession. It was held that by virtue of the said treaty they had a right to prove their priority, and the court awarded them 300 francs as damages, and condemned the defendants to pay all the costs. The case was thereupon appealed. The appellant's counsel argued, inter alia, that the respondent's firm had not enjoyed any reputation in France until very recently, that it was not shown that their firm was established in France until after the date of the treaty, that therefore their title should not be permitted to conflict with one that had a recognized popularity ever since 1834, and that, in fact, their manufactures were inferior in quality to those of the appellants, as was shown at the Great Exposition, where they got nothing, while Holzer & Company received a gold medal. The respondents' counsel argued that they were the seniors in their line of business, that the possession of their mark had constantly been maintained in Germany, and was proven by all the documents that could possibly be procured in a country where property in emblematic marks was not regulated by law, that their possession was established as far back as 1817, and that their long user was conclusive, the act of deposit not being declarative of property, and not attributive of a new right. He further claimed judgment, irrespective of the said treaty, by the French law of 1857, the 6th article of which provides that a foreigner whose establishment is outside of France, is admitted to enjoy the benefit of the law of deposit, if in the country where his establishment is situate. Diplomatic conventions had arranged reciprocity for Frenchmen. Concerning trademarks, the treaty says that the subjects of each of the contracting states shall respectively enjoy in the other the same protection as the natives thereof. Therefore, Lendenberg & Company had a right to invoke the protection of the French laws, the same as if they were French themselves, that by the law of 1857 the deposit of a trademark is not attributive, but simply declarative of property in that mark, that, in other words, the ownership of a trademark did not depend upon deposit, but that property existed independent of any species of deposit, although by not depositing one ran the risk of a use by others. Finally, Lendenberg and Company had a pre-existing right, the treaty gave a remedy. The court concurred in these views as matters of law. Section 51. The question thus raised was assuredly one of a most delicate and difficult nature, involving the effect of a treaty, affecting the rights of citizens of another country to a mark long used, and to which up to the time of the treaty they had the sole right of protection. But for our present purpose, it is necessary only to cite it as authority for saying that a trademark is not the creature of arbitrary law. That point has been affirmed in other French cases, and may be said to be definitively settled, and this is the recognized law of all civilized nations. The Tribunal of Commerce of Geneva, in 1859, Christoffel and Company v. Deliideria, held that a manufacturer's mark is property under the law of nations, and other nations by their judicial decisions have repeatedly affirmed the same doctrine, one founded upon sound reason. Thus, in 1855, the Tribunal of Brussels held that a Frenchman, domiciled in Paris, might in a Belgian court pursue an infringer of his mark, although the plaintiff had no treaty to stand upon, and based his claim to his mark upon the law of natural justice. Section 52. What time is required for the perfection of title? That is, how long does it take to adopt it? The answer is obviously this: the moment one who has selected a symbol to indicate his merchandise applies the mark to his goods, the act is complete. The avowal of his intention to adopt, his registration of the mark, and notice to the whole world, do not constitute adoption, but apply the mark to the articles for sale, and, eo instanti, the act is complete. In McAndrew v. Bassett, the right of the plaintiff was disputed because of his recent appropriation of the symbol to stamp his licorice, just as a claim based upon mere prescription might be challenged. The Lord Chancellor said that he had been much pressed by the defendant's counsel to declare that there was not sufficient time between the termination of the month of July and the 13th of September following for the plaintiffs to acquire a right of property in the particular trademark. The substance of the argument of defendants is this, that, supposing the court interfere upon the ground of property in a trademark, that property must be regarded as the offspring of such an antecedent user as will be sufficient to have acquired for the article stamped general notoriety and reputation in the market, and that the property cannot be held to exist until the fact of the general user, that notoriety and that public reputation have been proved to exist. The plaintiffs 1. Section 53. Who may acquire property in a trademark? As a general proposition, any person who, in law, is capable of acquiring and holding any species of property, may hold a title to a trademark. Section 54. Yet this sweeping assertion must be subjected to some qualification, for unless the person be a trader, that is, unless he or she be engaged in mercantile business of some kind, such a title could not be acquired, as we shall hereafter more clearly see. The reason of such a condition is this: the object selected as a trademark does not become such by the mere act of selection. Something more is requisite to perfect an act of adoption. What is that something? It is the union of the abstract representation of the object with a vendible commodity. Instantly the inchoate right becomes perfect, and title rests in the appropriator. Section 55. But we shall see that certain persons cannot become traders, and consequently cannot place themselves in a position to obtain such a title. Take as an extreme hypothesis the case of the person holding the office of Archbishop of Canterbury. He could not become possessed of a title to a trademark, for the law inhibits him from engaging in secular pursuits of a mercantile nature. A corporation is an artificial person, and under an Act of Congress of July 8, 1870, the right of a corporation to a trademark is distinctly recognized. But, when we come to consider the provisions of that act, we shall be easily convinced that it is not every corporation that can avail itself of the protection promised thereby. Why? Because the corporation may not be a trading corporation. For instance, a rector of a parish in Massachusetts, New York, Maryland, and other states where the Church of England once held legal sway, is a corporation sold. Yet no sane person would dream of such a corporation, or any other of a purely ecclesiastical nature, manufacturing or selling goods. Section 56. Nor can every natural person hold title in a trademark, for some persons are under interdict, are felons under sentence of death, or are not of sound mind. This phase we shall also more fully investigate hereafter. Section 57. The conditions upon which a right can be enjoyed and guaranteed are few and simple. Be he citizen or alien, the owner has protection provided he is engaged in lawful business, conducted with sincerity. Section 58. Who is an infringer? He who imitates in whole or in part the peculiar emblem or mark to which another has the right of exclusive use, provided he use it to indicate the same class of goods. The imitator may be the pirate himself, or he may be an innocent vendor of the article bearing the mark. Both are in intendment of law infringers, although the one may be guilty of gross roguery and the other be free from the imputation of turpitude. The law will correct the illegal act of either, but will deal more leniently with the unintentional trespasser. Section 59. So similar in external appearance are different articles of merchandise, that, without peculiar indication of some kind, one would be in uncertainty. Some pledge of integrity is demanded. We see a curious mark, it is enough. It conveys to the mind full assurance of excellence, or what we are happy in believing to be such. Some such guarantee is required in these days when traffic moves swiftly, in harmony with agencies of steam and electricity. A glance, it is enough. Down goes the cash, and the change is effected. But what if the signal with its blazon of truth be false? Confidence is outraged, and that is 1,000-fold worse than the immediate loss of money, for a scar of suspicion is left. Severe measures must be enforced to restrain the commission of crime which has no small resemblance to that of wretches who display false signal lights. Avarice and treachery. Piracy must be restrained by the iron grasp of justice, that laudable industry may flourish, and competition, the life of trade, be stimulated to ever fresh efforts for excellence. Inadequate security and protection may be found in the extension of the powers of courts of justice in the endeavor to uphold a high mercantile morality. In this there is no restraint of the freedom of trade, no fostering of monopolies. Each man stands upon his own merits, just as a knight at a tourney has his own color to identify him with valor and high emprise. Infamy would await the base dastard who took the pennon not belonging to him. So should it be in the mammoth contest for the well-earned meed of honorable and laborious enterprise. Section 60. Protection. What avails a mere naked title to anything, unless the law protect it? Any man may copy an emblem or a mere representation of an object, no matter whether it be of the rudest character or whether it be delineated with all the grace and beauty of accomplished art, unless the exclusive property in it be secured by local law in another person. We say local, for a right to exclusively make and sell a representation of an object, or a fanciful picture, or other mark of taste, rests upon nothing more extensive than the laws of the country which has invested it with the aegis of defense. One nation does not respect the defensive law of another in respect to such work of art, unless bound to do so by a treaty or compact. The people of one country, then, may with impunity prey upon the people of any other in respect to works of genius, unless, upon the condition of reciprocity, mutual forbearance shall have been stipulated. This reflection begets an idea. Section 61. It is not the act of imitating that is unlawful in regard to a trade sign or mark. Then what is the wrongful act? It is this: the placing of that mark upon vendible goods, for the purpose of fraud. For fraud, actual or constructive, of this species of cheating, furtive and mean, the honest, the confiding, are the victims. But then the law protects the innocent against fraud. Yes, now we perceived that fraud is the basis of the law's intervention, that kind of fraud which a person practices when he writes or paints or stamps or brands a certain sign upon articles for sale, with the design that the public shall take them to be the manufacture of some person else, or to have emanated from some place which is not the true one. This is a matter of property. A trader's business fails because another trader has illicitly copied his mark of honest dealing. He loses what should come to him as just profits, and the purchaser is deceived into paying for a false article. A double wrong is done. Unless the law intervene to preserve the credit of the mark, all faith in its integrity shall soon be destroyed. Commerce is wounded. Real tangible rights are struck at. Money is lost. That in the eye of the law, as administered, is a greater wrong than to kidnap and sell the children of another's brain. Property has been despoiled, and that by the simple act of causing a certain symbol to utter a falsehood. Property must be protected. Section 62. Whose rights are protected? those of the manufacturer or merchant who has lost his just profits, or of him who has been cajoled out of his money, or both. We must examine into the theory of protection, for upon a right understanding of it frequently depends the possibility of redress. Section 63. When we look at the case in Crow, Jack, we find that, for an imitation of a mark placed upon cloth, an action upon the case was brought by him who bought the cloth, for deceit, which action was adjudged to be maintainable. In Southern v. Howe, which is believed to be the same case, a different version is given. In Commonwealth's Digest, action on the case for deceit, a.g., the case is thus cited, so, i.e., an action will lie, if a clothier sell bad cloths upon which he put the mark of another who made good cloths. Comment does not say by whom the action may be maintained, but as he cites Crow, Jack. Only, it may be inferred that he considered the case as establishing the right in the purchaser, which it certainly would, if that report is correct. In Southern v. How the case is certainly cited as a distinct affirmance of the right of a manufacturer to maintain an action for an unauthorized use of his trademark. Lord Rolle, however, expressly states that Doddridge did not say whether the action was brought by the clothier or by the vendee, but he adds, semble cagist per la vendee, to Rolle. 28. Therefore, if we depend upon the old books, we are left in doubt as to who is the protected party. But, fortunately, the question may be said to be settled in these days, although in the minds of some chancellors there is a lingering doubt whether the public have any right to protection in such a case. Section 64. We may safely assume that it is the moral, if not the legal, duty of a court to protect the public against fraud, perpetrated by means of false tokens. The maxim quoted by Lord Cranworth in the case of the leather companies, vigilantibus, non dormientibus leges subveniunt, is not always a proved doctrine, for not only the watchful but the careless should be guarded against wily craft and cunning. The morals of a nation are like those of an individual. They must be guarded by the supervising power, whatever that may be. In this matter it is the Court of Justice trying the question of infringement upon a mark of trade. The law of gravitation seems to operate in morals as in physics. There is an increased momentum at every stage of descent. Of this we have had melancholy proof in recent developments in some portions of our country, where corruption soiled even the ermine of the judge. When we read of excessive stickling for legality, we are apt to suspect that moral obligations have not due weight. When a rogue stands convicted of his offense, why not punish him to the extent of his merits? In trademark cases there is a great laxity, as if the community at large had no interest in the upholding of mercantile honor. Spasmodic pretenses to severity do not help the matter. Let punishment be sure, like the bodily pain which follows every excess as a manifestation of divine will, and fraud must decrease. Whether by corporal pain or pecuniary mulct, the effect would be beneficent. The law should protect the weak and the simple. Is the child or the illiterate clown to be plundered at the will of any charlatan or knave? Is the law to lend its aid only to the vigilant, who require it not? It must be that the exponents of justice have sometimes, by mistaking the intent of the law, become false oracles. If the reasoning sometimes used is good in one case, then why not in another? If the confiding purchaser of wares may be cheated with impunity, why not also suffer the pickpocket to ply his craft unmolested against the youthful, the thoughtless, the unsuspecting? Would it be a good defense for a vendor of brass watches bearing the mark of the American, the Elgin, or any other reputable watch company, to plead that prudent examination would have detected the fraud? Verily not. Does one prudent person in 1,000 keenly scrutinize each article he buys? What percentage of ordinarily cautious persons closely examine the printed national currency, to see that it bears all its legitimate marks? We come to the conclusion that the rule of caveat emptor should be changed into caveat venditor, demanding sincerity in the seller, rather than extreme caution in the purchaser. Section 65. There seems to be a contrariety of opinion among judges, both in law and equity, as to the real principle upon which is founded the duty of judicial intervention. Some judges, remarkable for probity in private life, appear to permit the ermine to stifle sentiments of the nobler morality, and to deal with the rigid letter of the law, rather than with its equitable spirit. They base their action entirely upon the legal right of the party complainant, and treat as a matter of little or no consequence the fact that the public at large have some right to protection. Conceding that a court cannot go outside of the immediate case presented, is it not true that the rights of the public may be guarded and vindicated by holding the simulator of trademarks to a rigid responsibility? Woodbury, J., in one case, uttered the true doctrine, to elevate our own character as a nation, and the purity of our judicial tribunals. It seems to me we ought to go as far in the redress and punishment of these deceptions as can be vindicated on any sound principle. Robertson, J., in the case of Corwin v. Daly, said that the origin of the favor shown to trademarks was the protection of the public, and not merely of the individual dealer, and in speaking of the scope or design of a bill in Chancery, invoking protection for honest trade, Lott, Senator, said, its object is to prevent the commission of a fraud not only on them and to the prejudice of their rights, but on the public, by the sale of an article with an imitation of their trademark thereon in such a manner as to deceive purchasers, and through the false representations thus held out, to deprive the owners thereof of the profits of their skill and enterprise. Honest competition relies only on the intrinsic merit of the article brought into the market, and does not require a resort to a false or fraudulent device or token. It is undoubtedly the duty of courts to regard with disfavor every establishment having any tendency to corrupt the public morals, to create idle or dissipated habits, to encourage a craving for undue excitement, or to impair the taste for domestic attachments and domestic society, said another judge. Section 66. Class of goods. Protection will not be given unless in connection with the class of goods to which the mark has been applied. Vice-Chancellor Wood, 5 in 1865, remarked that the court had taken on itself to protect a man in the use of a trademark as applied to a particular description of article. He has no property in that mark, per se, any more than a person has in any fanciful denomination which he may assume for his own particular use, without reference to his trade. If he does not carry on a trade in iron, but carries on a trade in linen, and stamps a line on his linen, another person may stamp a lion on iron, but when he has appropriated a mark to a particular species of goods, and when he has caused his goods to circulate with that mark, when that mark has become the known indicium of their being his, the court has said that nobody shall defraud him by using that mark and passing off the goods of another's manufacture as being the goods of the owner of the mark. Section 67. As the first adopter of a mark does not acquire any exclusive right to its use, except in connection with the specific class to which he has applied it, it is not uncommon for the same mark to be placed upon different classes by different owners. The word magnolia may properly serve to indicate a certain manufacture of gin for one proprietor, and a certain brand of whiskey for another. For although both contain a large proportion of alcohol, the fluids cannot be said to belong to the same class, and the fanciful appellation of Bismarck may in complement to the Statesman be used for cement, notwithstanding the fact that another had previously appropriated it for paper collars. Section 68. The importance of a specific mention of the class of merchandise to which a certain emblem is to be attached as a trademark, may be illustrated by the letters IXL. To guard against looseness in practice, the statute requires that the class, and the particular description of goods comprised in such class, shall be set forth in the application. Time out of mind. The manufacturing establishment of Wostenham, in England, has used the letters IXL upon cutlery. The exclusive right to the use of that symbol had at common law become vested in that firm. So far as it was actually stamped upon certain articles, it could properly have been appropriated for marking all kinds of cutlery, fine and common, large and small. The mark was known all over the world, and by it was understood that the House of Wostenham had manufactured the steel fabrics thus stamped. The examiner was well aware of the existence of that mark, and recognized its import. It was his duty to refuse registration to anyone else who claimed property in that mark, as applied to the particular class of goods made and so marked by the English House. It did not matter that no official notice of the use of the mark in a foreign country had been filed. It was enough that a claimant must have been the prior adopter of it. Section 69. An American firm, doing business at Evansville, Indiana, applied for registration of that mark for a chopping axe. They did not pretend to have adopted the symbol before the year 1870, many years after it had acquired a universal reputation through the English firm of Wostenham, held, chopping axes are not included in the particular class of goods in which the Wostenhams used the mark. Registration allowed. Section 70. In January, 1872, Wostenham and Son, of England, filed an application for the registration of the said symbol, 9L, as a trademark for cutlery. They set forth the long term of years during which their firm had used it for the same purpose. The certificate of registry was duly issued. In March, 1872, a manufacturing company in Hartford, Connecticut, filed an application for a mark, newly adopted, of which the said symbol is the essential part. It was to be applied to scythes. The case was suspended until evidence was furnished that the English firm of Wostenham did not make scythes. The adoption by the Hartford Company was therefore lawful, and the mark was registered for the third time. Section 71. A lack of truth debars a trademark from protection. The tale told by the symbol must be sincere. The instant it ceases to be truthful, in spirit as well as in letter, it becomes an instrument of fraud, and is not lawful. A qualification, true in itself, may become fraudulent by the manner in which it is used. In a case before the Tribunal of Correction of Thanville, in 1865, it was held, where a French gunmaker establishes himself and his manufactory in a foreign country, and places his name on his products as of Paris, although really a Parisian, it is bad faith in him. His intention was evidently to cause purchasers to believe that he was the person of that name, who carried on business in that city. When his merchandise was brought into France to compete with honest goods, his deception was sufficient authority for confiscating it. Section 72. An untrue use of the word patented, or its equivalent. If a trademark represents an article as protected by a patent, when in fact it is not patented, such a statement prima facie amounts to a misrepresentation of an important fact, which would disentitle the owner of the mark to relief in a court of equity against a pirate. That is clearly so when the pretended patent had never existed. In the case of Idleston v. Vic, 5 Vice-Chancellor Wood intimated a doubt whether the rule would be the same if there had originally been a patent, and the statement in the trademark being true when first introduced, had been continued after it had ceased to be true. Lord Kingsdown, in the leathercloth case, declined to assent to that distinction. He thought that if the word patent be not so used as to indicate the existing protection of a patent, but merely as part of the designation of an article known in the market by that term, then he quite agreed in that view. He said that a patent may have expired 50 years ago, and yet the name of patent may have become attached to the article, and be used in the trade as designating it. But if the trademark represents the article as protected by patent, when in fact it is not so protected, it can make no difference whether the protection never existed or has ceased to exist. In the more recent case of Marshall v. Ross, in 1869, it was held that the use of the word patent as part of the description in a label or trademark of goods not protected by a patent, is not such a misrepresentation as to deprive the owner of his right to be protected against an infringement of his label, where the goods have from the usage of many years acquired the designation in the trade generally of patent. Sir W. M. James, V.C., said that he could grant the plaintiff the relief which justice requires without interfering with the decision of the House of Lords in the Leathercloth Company's case above cited, for the word patent may be used in such a way as not to deceive the public. For instance, he said, the term patent leather boots is in constant use, but no one supposes that it is thereby intended to convey the impression that the leather is protected by any patent. In this case, it was shown that the term patent thread had been used in the trade for many years past, and was the name by which thread of a certain class is known by manufacturers, and in the trade it had in fact, he said, become a word of art. Section 73. The case of Idleston v. Vic, in the High Court of Chancery, in 1853, is as follows. T. took out letters patent, which expired in 1844, for the manufacture of solid-headed pins, and carried on the business under the firm of T. and Co. till 1838. In such business T. used parti-colored labels, in pink and green, in which the pins were described as patent pins, exclusively manufactured by T. and Co., and had engraved plates and blocks for striking off said labels. In 1838, T. assigned to S. The letters patent, together with his business and goodwill, and the right to use the plates, labels, and C, and the name of T and Co. in 1839, S. became bankrupt. His assignees carried on the trade till 1841, when they assigned the business, patent, plates, labels, and C, with the right to use the name of T and Co. to Idleston, the plaintiff, who continued the business and the use of the labels. In 1853, Idleston discovered that Vic, the defendant, was using labels like those of the plaintiff. Held, first, that Idleston was entitled to restrain such palpable imitation. Secondly, that Idleston was not disentitled to sue by reason of the representation on his label being no longer accurate, although the pins were not still protected by patent, nor manufactured strictly according to the patent, nor exclusively or at all by T, who had long since retired. Thirdly, that Vic was not to be precluded altogether from representing that his pins were manufactured according to T.'s expired patent, but he was not to do so in a manner liable to mislead. Section 74. Argument is not necessary to persuade any thinking person of the necessity that exists for the protecting instrumentalities of the law. In olden times in England, the trade guilds and corporate bodies looked especially to the maintenance of a high character of workmanship on broadcloths, cutlery, hardwares, and other principal manufactures. The penal law of that country is severe upon the reprobates who turn the lawful weapon of defense into the weapon of the robber, by simulating the marks that commerce uses as a safeguard. The crown has its distinguishing broad arrow for some kinds of property, and its yellow thread in cordage, and the possession of either kind by a private individual is presumptive evidence of felony, as much as the possession of false dies or tools for counterfeiting the currency. Our own government finds it necessary by similar stringent measures to protect its own peculiar marks, as, for example, in the matter of the various colored threads scattered through the fiber of the paper on which the national securities are printed. Nearly all nations have observed the absolute necessity of severe penal laws to the same end, while not a few have adopted the same rules as ours in regard to the fraudulent invasion of private rights. The more flourishing becomes commerce, the more general are piracies of this kind. While we may reasonably infer from circumstances that no ancient nation was exempt from such roguery, we have indubitable evidence that all nations of our own times are wonderfully enterprising in this respect. Almost all articles of merchandise possessing a high reputation in Europe are extensively imported into the United States. Their excellences and ready sale excites the cupidity of the fraudulent dealer, and therefore hides sick champagne, other wines and brandies, Bess and Lubiness extracts, and all the various descriptions of toilet articles, Rogers's cutlery, Worcestershire sauce, burnt nails, Irish linen, French silks, Scotch shawls, in short the innumerable other articles of luxury or of necessity, are imitated, falsely marked, and sold. These frauds are committed under the very eyes of the honest manufacturer, and carried out with so much satanic skill as to elude any but the most vigilant search. Our country has probably been the greatest victim. Even fabrics in which our workshops excel have been brought from Belgium, France, Switzerland, and put into competition with the genuine goods. The reputation of American watches has brought an avalanche of miserable imitations from Geneva, till Congress has been compelled to pass a statute expressly for the purpose of interposing a barrier against them. The Germans imitate the Irish marks on linen, the French, the English marks on nails, cutlery, and the English, the French marks on wines. No nation can claim precedence of any other in such illicit competition, so far as means allow. In the Supreme Court of Calcutta, in 1854, the native defendant was shown to have pirated the English trademarks on grey shirtings of an inferior quality. That case developed the fact that such imitations had been carried to a considerable extent. We are told that it was the custom at Worcester, England, to copy a great variety of Chinese and Japanese patterns on porcelain, and with such good effect that the copies were frequently mistaken for originals. The marks were simulated exactly. Section 75. M. Jobard, more than a score of years since, expressed his sorrow that the revolution in France in 1793 had broken down the law of obligatory marks, that honorable source of confidence and of commercial prosperity, which lost to France all the openings of the Orient. The Levantines, habituated for centuries to the sincerity of the marks guaranteed by the arms of the city of Nîmes, Avignon, Lyon, and C, with horror observed the inroads of counterfeiters. The Turkish merchants, no longer confiding in the honor of the French, themselves repaired to Marseille, Caire, Lyon. But they were cheated as easily nearby as afar off, several of the principal ones having paid at Lyon for golden fabrics, by order of the Grand Seigneur, unwittingly delivered brass to him. He beheaded them. Thus much for implicit faith in trademarks. Section 76. We may instance the injury done to national confidence by false coinage, the simulation of the mark of the sovereign. Private coinage is not allowed. Coin is intrinsically worth nothing, or next to nothing, beyond its weight of gold or silver, in mass. The public faith is a sufficient guarantee of the genuineness of a coin. Counterfeit coins are almost always of inferior composition and value, and are fabricated for the purpose of imposing them upon the public as genuine, and gaining the difference. And yet it is possible that the public may be deceived and at the same time not injured. This may be illustrated by a case which occurred in Tunis in 1828. A coinage of new piastres was effected under the direction of the Bey, and on account of his government, the sovereign reaping the enormous profit of more than 40%. Piastres of a similar impression, weight, and value, were fabricated in Europe, and found their way to Tunis, where they entered into the circulation, and procured for their makers a division of the spoils. Still the piracy was no less in law, even had the counterfeiters furnished a superior coin, the rule being that the public may not be deceived, even for its own benefit. Not many years ago, the base silver money of Haiti was imitated by artisans in this country, upon similar speculative ideas. It may also be remembered that, during our late civil war of the rebellion, the worthless notes of the Confederate States were imitated by lithographers and printers in the North, and, being more artistically executed than were the genuine, were all the more greedily sought for. Yet the man who sold a cow for a pretty-looking counterfeit note, was declared in law to be cheated, even although the genuine note was doomed never to be redeemed, for his contract was for a genuine promise to pay. The cases fairly illustrate the principle of trademarks, so far as the obligation to deliver to the purchaser the thing bargained for, whatever its intrinsic value. Section 77. None of the actors in the following case would have had any standing in court, as applicants for protection. Years ago, the wine growers of Montana Rache and of Chablis heard that monks in Aix were exporting white wine to Turkey, under the name of mineral water. So thrifty an example was not to be despised, so white wine from Burgundy was sent to the Turks under the same disguise, and was declared by the consignees as well as by the exporters to be as good mineral water as that of Aix. Here was a case of competition in business by unfair means. Suppose that the pious fathers of Aix had prosecuted their rivals in trade for the imitation of their mark, to wit, the meaningless, arbitrary symbol, mineral water. Could a suit have been maintained? No. But nobody was deceived. True. But the business was immoral. Immoral to sell wine? No. But immoral to sell to Turks, because their religion forbids them to drink it. Section 78. Manufactures and commerce are, it is plain to perceive, twin sisters. As they began life together, so in the race do they keep side by side. The plastic hand of the cunning workman molds and fashions and shapes, while the merchant, scattering his products afar in all directions, by barter receives from afar the products of other countries. All the world should be enabled to test the genuineness of goods by the mark placed upon them. When the distinguishing symbol is once published, it should be susceptible of being read as easily as the child or the dog, by intuition or by instinct, reads the marks that nature has legibly written on the countenance of man. The first glance of the eye decides. This is a rule in connection with trademarks. Section 79. How shall we judge a mark? We must learn something of its peculiar nature, for it is not every heterogeneous assemblage of objects that comes within the category of trademarks, nor every protean representation, that may be one thing today, another thing tomorrow. We must apply a touchstone to anything claiming to be the symbol of trade. We must learn to discern the true from the false, that is, the one having the true essence from that which has but a faint semblance of reality. We need not there are certain tests. But this leads us to another chapter. which treats of the nature of the thing,